In your situation, since you handle criminal defense cases as well as immigration cases, how do you handle them differently than someone who specializes in just criminal defense or immigration?
It's a really good question, and what those two specialties allow me to do is consider the question from the perspective of the immigrant charged with a criminal offense differently than a non-immigrant, meaning a citizen charged with a criminal offense. And what I understand, and what is true, I would say, in probably 99% of those cases, is that the most important outcome, the most important result of the criminal case is not jail time or probation or having a criminal history. It's the ability to remain in the United States with their family and with their friends and where their life has been. And so I'm willing to, and I insist of my clients to be willing to fight that extra mile to get the result, to get a plea agreement, to go to trial, to do what we need to do, what we might not need to do for someone who is a U.S. citizen. And that is the major difference. So I can give you an example of somebody, because I think it just illustrates exactly what it is I do differently than people who practice criminal defense solely, is that with that understanding, I'll come up with some different counter offers to the prosecutor's plea agreements that most people wouldn't think of. For instance, I had a client who was charged with second-degree possession of controlled dangerous substance, drugs, with the intent to distribute. That's a crime that faces 5 to 10 years in prison and is mandatory deportation. The prosecutor's plea offer was a third-degree possession of controlled substances without the distribution, which is better for immigration purposes, but for this particular client, didn't solve the problem, would still lead to certain deportation and the inability to ever come back. And so my counteroffer, with of course the client's consultation and deep thought and consideration, was we need a lower degree charge, even lower than that, what we call in New Jersey disorderly persons offense, our equivalent of a misdemeanor. And in order to get the prosecutor to give us that offense, we had to offer for her to do 180 days in jail. And so she did 180 days in jail, and she got that lower degree offense, and she maintained the ability to remain in the United States. And certainly that's not something that a U.S. citizen would ever consider doing.
Interesting.